No, unless it was that, I didn't get a special thing for the sales.
All right. The Court of Appeal in and for the Sixth District of the State of Florida is now in session. The Honorable Dan Traver, Chief Judge presiding. All persons having business before the court draw near, give attention, and will be heard. May God save the United States of America, the State of Florida, and the Honorable Court. Please be seated.
Thank you, Deputy Marshal. Good morning, everybody. Welcome to an oral argument session of the Sixth District Court of Appeal. I'm Dan Traver. I'll be presiding today. To my right is the Honorable Mary Nardella. To my left is the Honorable Keith White. We have one case on today's docket. Before we call the case, I will let you know what you already know, which is that this case is being streamed live on YouTube. If you have not already done us the kindness of silencing your cell phones, we'd be grateful if you did. The case on the docket today is case number 23-2139, Florida Investments Unlimited, Inc., doing business as Team Staffing Services, and Deborah Jones versus Kathleen Tumarello as personal representative of the estate of Tina Marie Smith et al. Typical is going to be 5 minutes of rebuttal for the appellant. Would you like to keep that, or would you like to? Oh, guys, got me in different places. Okay. Would you? Five's good at your convenience.
May it please the court. Good morning. Mark Tinker on behalf of Florida Investments Unlimited and Deborah Jones. I'd like to start today with talking about the standards to be applied. We agree that the court has de novo review over this issue. We're talking about an amendment to allow punitive damages. But in the briefs, we have kind of a fundamental disagreement as to what the court is supposed to do, what standard you're supposed to apply. What Tumarello would like you to do is apply a standard to say this is just like any other amendment to a complaint. You have to take all allegations as true and resolve all inferences in their favor. And that's just wrong. Where they get that from is about a 20-year-old 4th District case. It was Holmes versus Bridgestone, I believe is the name of it, where the court actually analogized a punitive amendment to a regular amendment into summary judgments and said that the same standard should be applied. But the 4th District has since come out with several cases to explain that has been misinterpreted. What they said, that what they meant when they made that analogy is they're saying we analogize it to the extent that those are all questions of law that are reviewed de novo on appeal. We weren't meaning to say that a punitive amendment is considered in the first instance as the trial judge, or when you're on de novo review, this court is not to be considered under the same standards as any other amendment where you give the plaintiff, the pleading party, the benefit of all doubt and take their allegations as true. What you do have to do is the trial judge, and now this court, sits as a fact finder. You actually have to consider both sides' proffers, and you have to resolve conflicts in the evidence and do exactly that, sit as the fact finder and decide, does this case rise to the level necessary to state a claim for punitive damages? And
Counsel, isn't that argument though inconsistent with the de novo standard of review? And let me ask you this, give me one example of where a fact finder weighs evidence and then on review, the standard of the appellate court is de novo.
it is that way because there is no live testimony being taken. You are reading exactly the same proffer that the trial judge saw. We provided for you in the appendix, the entire proffer is there. So you're looking at exactly the same thing. That is why it is, you're resolving conflicts the same way the trial judge did, looking at the same things. There's no deference because there's no, the trial judge didn't see a witness testify, didn't get to see their demeanor and, all those things that we normally would have to give deference to when you're talking about a fact finder as in a jury or somebody, sitting at trial and resolving fact conflicts. In this context,
counsel, and I agree with that, but it would be impossible for even the trial judge or us to evaluate the credibility and demeanor of a witness if that's the appropriate standard. So to accept your standard, we essentially, the proffering party loses the ability of the finder of fact to evaluate the demeanor of the witness in order for the judge to weigh the proffer. For example, if your client proffers a witness by deposition testimony, I don't know if that individual would have been in front of me. I would have thought he was the most credible witness I've ever heard in my career or the biggest liar I've ever seen in my life. How can we do that? Or the trial judge?
I think and you're not being asked, I don't believe, to try to make a credibility determination. But what you can do when weighing evidence is you can look at it. If one side presents an affidavit that is based on hearsay and is conclusory in nature, and the other side presents a first person observation fact affidavit, and they conflict, you can decide that the hearsay is probably less credible than the one that provides, this is what I saw directly. So you can make a credibility determination to that extent. So you're not looking at people and trying to assess their demeanor, but you can weigh evidence and decide, looking at, this is a completely conclusory affidavit. It has no value. It talks about things that would never come in at trial. You can look at admissibility, later on down the road. And I think that's going to be a big issue here when we get to it, is a lot of the affidavits that were filed. I'll take an example. They talk about prior issues with Ms. Jones, saying that she was involved in an altercation with a co-employee, somebody, they had a fight a few weeks before this incident. That has zero relevance to what happened on this date and whether her conduct in driving that day was punitive in nature. That is something that wouldn't ever come in at trial. So you can weigh it to the extent that there's an affidavit, but you can discount it because that's not relevant. It would never come in at trial. It wouldn't go to prove a claim for punitive damages. And I think, when we look at what has been argued in this case in the brief, there is a whole lot of that where
Before we get to the substance of it, let me just ask you a basic appellate burden question. So the statute talks about evidence in the record or proffered by a claimant. So as a part of our appellate record, we have, as a part of the initial brief appendix, everything that was proffered by claimant, correct? The appendix to the answer brief gives us only an additional deposition.
And that deposition was actually in the original proffer as well. It was a duplicate.
Exactly. The trial court talks about reviewing the entire record, including the untimely submissions by trial counsel, which included a video that we're not able to see because it's not part of our record. If that video, for example, illustrated something to the trial judge that we're not able to see as it related to speed, location, conduct, how are we in a position to second guess the trial judge?
Well, in this case, the trial judge, both at the end of the transcript, when he made his oral ruling and in his written ruling, he lists, here is what I reviewed. So he says, these are the things I reviewed. That video, if you want to use that as the example, the video is not one of those things. He lists out, I think it was A through G or H, something like that, exactly what he reviewed. And those have all been provided to you. So you're looking at exactly what the trial judge based his ruling on.
But the video of the subject incident is listed in his order. What it is.
He lists still photos from the video.
I'm seeing under paragraph 11.6 on page 3, video of subject incident.
And at the time of the ruling, when he made his ruling, he said, I looked at the still photos from the video. He does not say that he actually watched the video, and the video was never discussed at the hearing. Actually, at the hearing, Tomarillo's counsel said, we're going to rely on these photos as opposed to the video. So that is all that the trial judge looked at when he was making the ruling, and he made the ruling there live at the end of the hearing. He didn't go back in chambers and look at something else that hadn't been before him at that time.
How do you know?
Well, he announced his ruling on the record at the hearing and asked Tomarillo's counsel to prepare the order memorializing that ruling.
Yeah. And what if he looked at it and said, you know what, I should have found that too? I did look at that too. I just forgot to mention it when I was announcing my oral ruling.
Well, Your Honor, I mean, at this point, we provided everything that was in the proffer and that was before the court. If Tomarillo believes that that was additional information that would have been relevant to the court, then that should have been in the answer brief appendix as opposed to the same deposition that we'd already provided.
Do they have an appellate burden here?
They do not have a burden, but Your Honor, as far as if the court is going to look at everything that was proffered to the trial judge, again, we believe that we provided it all. If they thought that we were incorrect, then I believe that would have been their obligation to point that out. And they did not, because again, the trial judge made his ruling there orally at the end of the hearing and said, this is what I've considered. This is my decision. Please prepare me an order.
It's interesting to me the difference between Rule 9.000, which relates to the record, and 9.220, which relates to appendices. 9.200 seems to put a bit of a burden on us that if something's missing and we'd like to see it, then we shall ask the parties to provide it. I don't see a corresponding obligation on our part on 9.220. Do you?
No, Your Honor. I think Now, just getting back to, I think I'd like to get into the substance of, the punitive issue at this point. And like I said, in the answer brief, what is argued to this court is a lot of taking the allegations and accepting them as true, as opposed to what the actual proper shows and what the facts are. And one of the big things is the answer brief repeatedly talks about Miss Jones speeding. And there is no evidence of speeding in this proffer. They had an accident reconstruction expert go out and, take all kinds of measurements and do everything. And the one thing that's missing from her affidavit is any reference to speed. She doesn't quantify speed.
Counsel, that struck me as well. And I want to talk a little bit about that. To determine whether or not somebody's speeding, you have to know two things, don't you? You have to know how fast they're going and you have to know how fast they should have been going.
Correct.
Are either pieces of those in the record
They're
or
not.
in the proffer?
No.
Okay, when it comes to crossing into the pedestrian zone, does anywhere in the record tell us how far into the pedestrian zone the vehicle went?
Not other than the still photos. There were, I believe, 8 still photos that were provided in the proffer from the video. They show, from my view of them, they show the left tires in the, pedestrian zone. And I want to get to the pedestrian zone thing. They show the left tires in and the right tires out. So just kind of half and half in the zone.
When it comes to the individuality of each car operates differently. We know this. When it comes to this specific car, is there anything in the record that tells us anything about this specific car and how it operates?
No, there is not.
When
Well-
it comes to how fast this car goes from rest, is there anything in the record that tells us that?
There is not. The only thing that we know about this car is that it was an Audi Q7, a 2007, I believe, 2005 possibly. I think it's 2007. So we know, that it was an Audi SUV, just from what we can look at, it's either a V6 or a large V8 engine in it. That is one of the things that struck me is there's, their expert affidavit didn't talk about speed, but it says that very obviously Miss Jones must have hit the gas because the car was moving. And I mean, I think it's kind of something that, as far as weighing testimony we talked about, that is something in the affidavit that we can discount because anyone who's driven a gas driven vehicle, it's not an EV, it's a gas vehicle with either a V6 or a V8. When you take your foot off the brake, it's going to start moving without hitting the gas. So she's giving,
Sometimes yes,
offering opinions.
sometimes no.
Well, she's like, again, that's something that you can weigh, but I think the bigger part, and going to your questioning, Judge Nadella, is there is nothing to say what the speed is. Just to say somebody was speeding, quite frankly, the speed limit on I-4 is 70.
I don't want to be
People-
accused of eating dead horses, but wouldn't a video help with observing speed?
It would, but that to set an actual speed and decide if it was excessive or to
I mean,
decide what the
9901
speed was.
lets lay witnesses opine as those sorts of things. Like if I'm walking my dog down the street and I see somebody go by, I might not know whether they're going 38 or 42 miles an hour, but I might know that they're speeding. Is that a fair statement?
I think you would have to, and again, it goes to what Judge Nadella's question was, you'd have to know what the speed limit was. You'd have to be able to compare them.
Well, assume
And
the
then-
video shows somebody going 50 miles an hour. I know it doesn't, but my point, and I went back and I looked at what he said about his oral ruling, and what he says is, if you'll send it over to me with a memorandum that this is how I addressed the matter this morning pursuant to this hearing, and I'll go ahead and compare it to my 5 pages of notes and the other documents that I have, and go ahead and get an order signed. So I don't necessarily know if your argument is going to be kind of a criminal sentencing sort of argument that the oral proclamation controls. I don't necessarily know that that's corroborated by what was said in the civil hearing transcripts.
Well, I mean, what we do know is that the judge made the ruling, directed counsel to prepare the order, and that's the order he signed. So there's, I mean, we know that
Maybe
that
it
was-
resonated completely with his 5 pages of notes is what I'm suggesting. Just to the extent that I perhaps improperly took your answer before to say this is, this was his oral proclamation. I look back and just having had some experience at the trial court level, like a lot of times I'd take a whole bunch of notes, I'd look at the order, maybe I'd strike some things out I didn't like, maybe I'd add some things that I didn't. Sometimes I got an order that was just exactly what I thought it should be, signed it. But to the extent that he says, and this goes back to what my colleague said, to the extent that the order says, I looked at the video and we don't have the video, I feel like the video might answer my other colleagues' questions, or at least get more towards answering them than perhaps the expert affidavits do in the file. If you could react to that for me.
And it's difficult because I don't want to go outside of what's the record that we do have here to say, what the judge did with what was submitted to him. There's nothing to respond other than to say that he did make his oral ruling based upon the argument and what was presented to him there. And it was the same thing. He said, I find based upon my belief that she was speeding. So if he hadn't viewed the video yet, he was basing that on still photos, but he already thought she's speeding, which they concede in their answer brief is insufficient for punitive damages. Speeding alone is insufficient. And that she crossed over into the pedestrian zone. And the pedestrian zone is one of the things that I did want to address because it's been referred to, and this is basically just throughout the allegations, as a pedestrian safe zone, a pedestrian area. The undisputed testimony in the record, both from Mannheim's corporate representative and from team staffing, is that that wasn't a pedestrian area back there. No one was supposed to be walking back there. Mannheim said that those little curb areas, those are meant to keep the cars in, their separate spaces as they come out of the bays to keep them in their lanes. There's no crosswalks back there. If someone was there, they'd be stuck on an island because there's nowhere for them to go. That would be a pedestrian safe zone. That's not a pedestrian area, but that's the way it's been argued.
Counsel, that's interesting. I understand the phraseology argument that you're making. Is there any testimony that goes against that though?
That goes against it?
Yes. Was there any part of the evidence in the proffer that suggests that that named pedestrian safe zone is for pedestrians?
No, not that I am aware. I know I'm already getting into my rebuttal. I haven't addressed the issue as far as extending liability if it were to exist to the employer. We believe that the only thing that they could possibly do would be to try to attach liability through Mr. DeJesus. Again, looking at the actual evidence in the record is that Mr. DeJesus was at best what would be considered a mid-level manager. He will accept what they say is true, that he manages the auction sites. That's not all team staffing does. They do, ticketing at events. They do auctions and other auctions. They do, I'm trying to remember now all the things that their corporate counsel said that they do. They have temporary staff that they send out for all of these other jobs. He might be the auction person. That at best makes him a mid-level manager there, but he even testified himself that, and even in that capacity, he doesn't have the ability to fire anybody, to make any corporate decisions. Those corporate decisions belong to Ms. Steele, and there has been nothing to show that she actively condoned or ratified or participated in all of the alleged conduct that has been placed before the court. I'm well into my rebuttal, so I'd like to reserve the rest of my time.
Morning, counsel.
Good morning. May it please the court, Robert Hubbard on behalf of the appellee, Kathleen Tumarello, as personal representative of the estate of Tina Marie Smith. I'd like to start by addressing the legal standard issue. Counsel noted there's a fundamental disagreement between the parties on the standard, and I think that's fair based on what I just heard counsel describe. It is not our position that the trial court has to review the allegations in the complaint and accept those allegations as true. The trial court reviews the proffer of evidence and views that evidence in the light most favorable to the plaintiff. The trial court is not weighing evidence. So there's an important difference between accepting allegations as true and weighing evidence. And there's nothing in the case law. Even the fourth DCA has come out with cases more recently talking about the trial court considering a counter proffer or additional evidence proffered by the other parties. We cite the estate of Despain case from the 5th district where the court rejects that idea. And 5th DCA has taken an approach where the trial court is reviewing the proffer from the movement and making a determination of whether the standard has been satisfied based on that alone. The 4th DCA has come out and said, well, the trial judge should be able to consider counter evidence offered by the defendant, and that's the evidence in the record that the trial court can make a decision on.
Counsel, let me ask you this. Let's
Yes.
assume we accept that standard. Your opposing counsel just made the argument of habits client. So help me understand what evidence viewed in the light most favorable to your client shows that Deborah Jones was not just negligent, but grossly negligent as defined in the statute.
So the important piece when you look at the standard of gross negligence, conscious disregard or indifference to the life, safety, or rights of persons exposed to such conduct. So our view is that Jones knowingly drove the auction vehicle in a manner and under such circumstances as was likely to cause harm. The baseline or the starting point when trying to understand how she could be driving with a conscious disregard or indifference, we point to the Smith System safety video, because there's an important difference between taking a vehicle and driving it out on a public road and following the traffic rules and driving an auction vehicle in the auction setting. We highlighted some language in the safety video in our brief, some important points. I mean, an auction is a highly charged, energetic environment, a very unusual form of danger. One glance and you know that if things don't go just right, trouble can quickly follow. Think of the whole auction area as a large volatile intersection. Vehicles and people can come from you from anywhere. And at some point, they probably will. Finally, distracted people will be surrounding you. Their lack of attention will add to your responsibility. You are charged with navigating an assortment of vehicles through a complex mass of objects and people, and you need to be ready for whatever this hub of activity can throw at you. So this is the environment that Deborah Jones is driving a vehicle through. The takeaway from this is essentially, when you're moving through the auction lane, especially in the area of the auction building, you have to watch out for pedestrians. And even within the lane, you should expect that a customer or an employee might walk out in front of you.
But counsel, she's outside the building. That's undisputed, is it not?
When the accident occurred, yes, absolutely.
She's outside the
It's
building.
outside the building.
And so your opponent just came up and he said something which kind of shocked me. He said that there's no evidence in the record that what we're calling a pedestrian safe zone is a pedestrian safe zone. Is that untrue?
I think that is untrue. I mean, the team
Wait,
staffing,
where is it? Show me where it's not just a title that we've laid on a piece of area. Show me where somebody says this is where pedestrians are and we've designated pedestrians to be here and drivers know this specific area is a safe zone for them.
well, so Deborah Jones and Beth Steele, the owner of Team Staffing, didn't use that exact terminology, but both of them were questioned during their depositions about that area. Hey, are you allowed to go through this area? No, absolutely not. That along with the Smith System.
And I'm sorry, when you say you're not allowed to go through that area, you're saying a vehicle's not allowed to go or pedestrians aren't allowed?
Vehicle, that's an important point. Thank you. Deborah Jones, it's an important comparison between what you see in the still images, what the Smith System safety video describes about the environment, and then the way that when she's asked about, do you go in this area, she definitively says, no, you don't go there. So she knows that this is not an area that you drive through.
You guys call it a pedestrian safe zone. Where does that name come from? Who created that name?
I don't know where that
Did an
name.
advocate create that name, or is that a name you find in the evidence?
I am not sure whether that terminology was used in the depositions with Deborah Jones, or, I mean, I'm not aware of any policy or procedure that Mannheim would have where they would describe that as a pedestrian safe zone. Everybody who testified unanimously said that is an area that the vehicle is not supposed to go.
Did anybody testify that that is an area where people should go, that people are expected to go, that people are safe here? And that they've been told that, and that drivers know that there are people here? Because it's a different thing to tell a driver not to go someplace. It's very different than to tell them, if you go someplace, you could run over somebody, because this is where their safe area is.
Well, and so I don't recall anything in the deposition testimony where any individual discussed that specific question. To go back to the Smith System safety video, when you're in the auction building, when you're around the auction building, one of the specific areas, issues discussed in that is when you're exiting the auction building, you're still in that area, that volatile intersection. And so, again, you should be expecting that distracted people are going to be all around you. I mean, and this is, so you're still in the lane. When Deborah Jones is describing what she did, her version of it is that she stayed in the lane She never mashed the gas. She went to the end of the lane. She stopped. There's several areas where she testifies about how long she stopped, and I think there was some confusion.
Yeah,
there.
no, it's very telling how confused she was.
Right. And so it sounds like she stopped, she checked her mirrors. This is her account. She checked her mirrors, made sure everything was safe, and then she pulled out to go drive the car back to the spot and get another one.
Let me ask you this.
Yes.
In terms of Miss Jones's deposition, it seems that the incident that killed Miss Smith happened in the evening.
Late afternoon, early evening, I think that's fair. I mean, it was
It seems from Miss Jones's deposition. It seems from Miss Jones's deposition that she was there early in the morning, which is the last time she spoke to Miss Smith.
I believe that's fair.
And it also seemed from the deposition testimony of pretty much everyone at team staffing, including Miss Jones, is that you stayed in the same lane that you were assigned to throughout the day.
I believe that's correct.
Miss Jones said in her deposition that she wasn't sure whether it was the first time she'd been in that lane. Is how I understood it. But at least based on the testimony of how business was done, what do we make of the fact that she thought that there was a speed bump there, counterposed against the idea that she could have been or probably was driving through that lane all day? And I'm not focusing on the initial contact with Miss Smith. I'm focusing on her being dragged under the car for a period of time.
Well, so, our view is that when you're looking at her testimony about what happened, that she's going through this area that at least she admits, whether it's fair to call it a pedestrian safe zone or not, she knows she's not supposed to go there. So she's crossing over this area that she knows she's not supposed to be in a volatile intersection. She is traveling at a speed where she comes into contact with someone. It is totally unaware of her surroundings. There are no line of sight restrictions. I believe even she admitted that. And yet she continues forward until she runs over. I mean, you can tell from the still images, Miss Tina Marie Smith goes onto the hood of the vehicle first. Deborah Jones still doesn't realize it, continues driving forward, throws her off the vehicle onto the front, and then she runs over her. And it isn't until someone else comes forward and starts yelling at her and tells her to stop that she finally stops. And so our position is all of that evidence goes to her total lack of awareness in driving through an area where she knows she's not supposed to be driving. She does know that there's a possibility that pedestrians can be there.
Counsel, what evidence of distraction is there? No radio, right? She doesn't have a radio. She's not listening to the radio. She's not on her cell phone. We know that she's not allowed to have a cell phone. Is there any evidence that she's distracted? Well, she's talking to somebody. She's doing anything other than paying attention. Is there any evidence in the record other than the result?
Well, the idea that she hits an individual, that person falls on the hood of their vehicle, she gets thrown to the ground, and then she runs over that person. I mean, whether it's distraction or just not paying any attention, I don't know if that makes a difference.
When I look at those stills, I see, like you said, a volatile environment.
Right.
I agree with that. But doesn't that play both ways? Because her attention is going everywhere. I don't want to hit that car. I don't want to hit that car. I don't want to hit that car. I don't want to hit that person. How can we assume that volatility doesn't mean that she wasn't paying attention? Maybe she's paying attention to a lot of things.
Well, I think if you look at the Smith, the training that she received in that video, any time she is in the vicinity of that auction building, she should be prepared to stop at any moment. So there is no excuse based on how she is trained, and I think based on her own description of how she operates.
But is it true we don't know how fast her vehicle was going? I mean, what's the best record evidence that we have? We don't have an accident reconstructionist that tells us much about this accident.
So it's interesting. The only evidence that I could find of an exact speed comes in the Florida Highway Patrol report, which was filed by the defendant in the court below. And there is a fact witness. There's a summary.
Before you start talking about something that's outside the record. Yeah, I mean, so I understand you're being responsive to my colleague's question, but that was my whole point talking to Mr. Tinker about we don't know what we don't know. So I don't know how you're able to say something outside the record supports you or doesn't support you. The point is that we don't know.
Well, and Your Honor, I'm referring to the Florida Highway Patrol report. It is in the record. It was a document that was filed.
With the trial court.
Yes, yes,
It's not before us.
Your Honor, I don't have the exact site in front of me.
Mr. Tinker's nodding yes outside of his time, but he can talk to me about that on rebuttal. If I'm missing it, that's fine. My overarching issue is obviously the video.
Understood. And just as far as being able to provide the court with something in the record of a number, there was a fact witness who was interviewed, a summary of his interview where he says that she was traveling 10 to 15 miles an hour at the time of the incident. And if you look at the Mannheim.
How fast does she say she was going?
She says she never matched the gas, maybe 1 or 2 miles per hour, I believe is kind of the.
She does, and that's proffered. And then back to Judge Traver, the evidence that you just put before this court, is that in our record?
The 10 to 15 miles
Yes,
per hour?
sir.
Yeah, yes, that is in the Florida Highway Investigation Report.
The record site?
I don't have
appendix?
the record site in front of me, Your Honor, but I know it was filed as counter evidence by the defendant.
Just like the video. Maybe Mr. Tinker can help me back out on rebuttal, but I thought my point was that the counter evidence isn't before us.
Well, the counter evidence is part of the appendix that has been provided, part of the appendix to the initial brief. So it is.
This is where I would be helpful in terms of a record site, because if it's there, I'm not seeing it.
And I'm sure I can find it in a few minutes, Your Honor, and maybe do a supplemental filing.
We can absolutely look, but you're saying it's in the FHP?
Yes,
Okay, I'll see if we have it.
and so if you look at the,
Did Ms. Jones testify as far as whether she had any alcohol or drugs that day? Were there any questions on that in their depot?
she was asked and she said no.
Denied it.
Yes.
And how are we to, if the standard isn't as you articulate, how am I to weigh that evidence without seeing her before and being able to assess her demeanor?
Well, I don't think the court is in a position to do that. That is our position. It's why there's a de novo review in the first place, that the state of Bisphane case discusses the appellate court's review of the same documents that will be proffered to the trial court.
That's so then, what evidence is there in the record that she was drunk at the time of this incident?
So, well, first of all, it is our position, and this was an issue that we tried to clarify for the trial court, that in determining whether her conduct rose to the level of gross negligence on that date, the issue of whether she's intoxicated really is irrelevant. So the court doesn't need to consider that evidence in order to determine whether there was a conscious disregard or indifference. That comes from the evidence of her knowledge of the circumstances.
So is your answer none?
Well, so there's the fact witness affidavits that talk about a history of alcohol use before she drives. I would argue that the manner in which she drove the vehicle is possibly evidence that a jury could infer and draw the conclusion that she's intoxicated.
What's your answer as it relates to team staffing's liability? What's your best evidence in the proffer, best evidence or in the proffer as it relates to their corporate liability?
Well, so we would point to the evidence of really a pattern of issues relating to the negligent hiring, retention, supervision, and training of employees. And I say negligent because if you look at any one item on its own, it might be sufficient to create a claim on its own of negligent hiring. But when you look at from hiring Deborah Jones through lack of supervision and lack of training, and then continuing to keep her on and retaining her after issues have been brought to light, it's the totality of that evidence and the pattern of conduct and disregard that the company has toward safety that rises to the level of gross negligence. And
Is there evidence in the record from Ms. Steele's deposition that she was privy or part of the DNR process?
yes, well, there is testimony. I mean, she's familiar with the process. She can describe how it works. She knows when they stop putting reasons on the form.
Is there anything in the record that suggests that she was part of that decision-making process or was aware on an employee by employee level of who was DNR?
I think it is reasonable to infer based off her testimony that she was involved in that process. Edgar De Jesus testified about how he deferred to her on sensitive personnel issues. I would consider a DNR from an important client like Mannheim a sensitive personnel matter that she would have been involved in. And also remember, she testified both individually and in her capacity as a corporate representative. So if we're viewing the record in the light most favorable to my client, then I think it's reasonable to assume that she would have investigated. And if we're accepting the testimony in the affidavits as true, then she would have come across evidence that Deborah Jones was DNR'd and shouldn't have been driving that day. And then she lied about it during the depositions. And so obviously that's an issue that would have to be proved at trial, and these witnesses are going to have to be called. And at that point, they can be cross-examined and their credibility will be an issue that the jury can consider. We're not here telling the court that the fact witnesses are more believable than Deborah Jones, because it's just not an issue. The court's not in a position to make that determination. But we're at the pleading stage, and based on the statute, we believe that we've met that standard. Unless the court has any other questions, I would ask.
No, I don't want to walk away from this I want to make sure I know what I need to know. What is the record evidence of how far that vehicle crosses into what has been called the pedestrian safe zone?
I would point to the still images showing the vehicle going directly through.
How many tires go over it? 2, 4?
So I think you can look at the still images and the path of the vehicle, and you can tell that the entire vehicle is going. It's not as if the vehicle drifted over and it's going parallel, and the driver tires run alongside and clipper. This is a vehicle that comes out, cuts left, and fully crosses that area.
Is there any record evidence that pedestrians typically or can be expected to be in this safe zone?
I believe the Smith System training video is the best evidence that we have of that. And also the testimony from Deborah Jones and other individuals just recognizing that is an area that they are not supposed to be driving.
There's no evidence before us that puts this vehicle at any speed higher than 3 to 4 miles an hour. Is that true? Before us on our review.
I believe the Florida Highway Patrol report is before the court.
Okay.
I believe it's in.
You said that, I'm sorry.
What lines should I be looking at in these stills? Because at least the car that's in the stills in the appendix to the initial brief at 1056 to 1063 seem to show the only lines that I can see the cars between. What lines am I looking at?
I think if you look at the order of the photo in the record, it can be a little deceiving, because I think the later photos in time may come first. So you kind of have to trace it back to when you can see, I believe, the top right side. You'll see Tina Marie Smith standing in that safe zone. You can see the lines, and that's one of the comments that Judge Craner mentioned on the record, is that he was looking at the images. He could see clearly the lines on the ground that she was standing in them, and then the vehicle is coming across.
Okay, thank you.
Thank you.
Mr. Tinker, could you cast some clarity on that traffic report?
Yes,
Is that
Your
in the
Honor.
record?
It begins in the appendix at 1227. But my reading of that at page 1235, the report says that there is no available evidence of speed. So I'm not sure where any other numbers came from.
Thank you.
To answer the other question that you were just asking, Your Honor, is looking at those stills, the way they're oriented in the record, because they're put in there sideways because of the way that they're oriented, I guess. The lines that you're looking at are from the walls in between the bays extending upwards, and the way that the photos are there, or if you to turn them so that they're properly be extending out towards the right. Those are the.
One second.
those are the areas, and Judge Nardella, I'd like to address, you asked, you said you were surprised about it before, and I know you asked counsel as far as whether this was a pedestrian safe zone. That phrase does not appear in anyone's testimony. No one says that. It is undisputed. Ms. Lowenthal at record 706 says that there's not supposed to be any walking back there. Ms. Steele at 426 says the same thing, says no pedestrians are supposed to be behind the building. Ms. Santiago says that all pedestrians at 1034, all pedestrians are supposed to be inside the building. That's where they view the
Council,
vehicles.
can you give those sites again? 1034, what was the previous one?
1034 was Santiago, Steele was 426, Lowenthal was 706. There was also, questions about, weighing evidence. I know counsel said that no case law says that is the court's obligation. The fourth district in KIS group versus Moquin, I guess it's MOQUIN. I will read the quote to you. Quote, unlike consideration of a motion for summary judgment, which precludes the court from weighing the evidence or reaching conclusions therefrom, Section 768.72 necessarily requires the court to weigh the evidence and act as a fact finder, end quote. So that is the standard that the court's applying that we discussed earlier. You question that in the context of, any evidence of alcohol use on that day. It's undisputed again that there was none.
Why is it undisputed?
The accident investigating officers testified that on their observation, they saw no evidence of impairment. They would be available to come in and testify as fact witnesses to that. Mr.
Why
DeHace,
can't the finder of fact reject that testimony?
they could reject, but I'm telling you what's undisputed so far. Mr. DeJesus said he spent 2 hours with her after the accident. He saw no evidence of impairment. At the end of that 2 hours, he asked the officers if he could take her for a drug screening. He did. He took her at the Manheim property on site, had her do a urine screen, came up negative all the way down the panel. Anyone, all of the witnesses there said she, of course, denied that she had used any drugs or alcohol that day. So what they did is they filed these affidavits from people saying, we think we saw her drinking in the past. On the day in question, there's no evidence of anything, including the officers looking at her and saying there was no evidence of impairment. They didn't, cite her, charge her for anything. There was also a question about the DNRs as far as what Mr. DeJesus could do, and I'm getting into my time.
Once you finish.
Okay. The DNRs, first of all, what a DNR is it was explained is that could be anything. It could be that somebody was late to work, so that the client is the one who imposes the DNR, says, I don't want these temporary workers here anymore. If they were late to work, if they were sleeping, it doesn't have to be anything that was bad. It could be that they're too slow, that they weren't getting back, taking the cars to the parking lot fast enough. So it could have been anything. There were no DNRs here. And as far as who imposes them, it wasn't Mr. DeJesus. He didn't have any ability to fire anyone or do anything like that. It was the client that did it. Manheim would have had to put a DNR on this person.
Thank you.
Thank you.
Thank you all for the presentation. We'll take the case under advisement and we'll be in recess.